5603. There we should have Ms. Bliss and also Mr. McCarthy. So let's double check. I see Ms. Bliss is here. And Mr. McCarthy, are you on the line this morning?
Yes, I'm here.
All right, great. Good to have you here. Thanks. Thanks for being present. So we're here on a motion to compel brought by Ms. Bliss on behalf of her client, Ms. McCarthy, related to some requests for production, I believe. So I'll hear from Ms. Bliss.
Thank you, Your Honor. For the record, Carly Bliss on behalf of petitioner and moving party, namely Lisa McCarthy. As contained in my motion, the initial interrogatories were sent to Mr. McCarthy back in August of last year. There's been several correspondence between myself and Mr. McCarthy in written form via email and letters, as well as several phone conferences with him. There were two different CR26I conferences, one in September and another one in January of this year. To date, very sparse answers were provided to the interrogatories, which prompted one of those CR26I conferences. I notified Mr. McCarthy that all of his requests for productions, with the exception of the budget, still remained outstanding, that he needed to provide them. Unfortunately, we were forced to bring a motion before the court. I can acknowledge for the court that last week I did receive a March 3rd pay stub and a 2022 W-2, but otherwise nothing else has been provided to my office. My client provides for the court that she had no knowledge of the party's liabilities or assets for that matter. So unfortunately, these requests for productions are absolutely paramount to receive in order to move forward with this dissolution action. So we are asking for a substantial award of attorney's fees in the amount of $1,000, given the fact that there has been substantial efforts exerted to get these records from Mr. McCarthy to no avail.
Thank you, Ms. Bliss. One quick question, if I might. You mentioned that there's the pay stub, the W-2, and then the budget, and then the other RFPs or requests for productions have been or largely unfulfilled. Can you give me an estimate of the number of RFPs that have not been?
I did go ahead and I looked at my interrogatories this morning. I show 1, 2, 3, 4, 5, 6 essential RFPs, and those are just the standard additional pay stubs, some tax returns, bank records, the 401k and the pension information, other retirement information, liability information, so debts that the parties occurred during the marriage, and then information regarding the real property, the house.
Okay. All right. Thank you. All right. I'll hear from Mr. McCarthy, please.
Me and Carly spoke here a while back on the phone. The only thing she was waiting on was pay stub and my W-2. So I did turn my packet in, and that was the only documentation she was waiting on. And I got back from vacation after the last phone call we had. She asked me if I could drop those off within a couple of weeks. And I said, yeah. And I think it was probably 3 weeks, maybe afterwards. It was when I got back from visiting my daughter in college. I delivered them to their office. I don't really know what else they could really want. Me and Lisa have been split up since 2018. So the property that they're talking about, there's no property that we have together. There's nothing, we'd have no debts together. So I really don't know what else they want. We spoke on the phone. She asked for a W-2 and pay stub, and she's got it.
Have you provided any information related to retirement, 401k, pension, that type of information?
Well, it was on when we spoke on the phone about it. I told her I have a PERS system that I'm on, so I don't really have any information. I told her I didn't really know what I could provide. I get like a yearly pension through the government, so I don't know.
Are there any documents that are produced through that PERS system and that you could supply?
I don't get any like statements or anything because I don't have 401k. I don't have anything like that. I get 2% a year of service for I'm a city employee. So
okay.
And I explained that to her, and she said, "Well, can you just give me a pay stub?" And I think it has like what it pulls out of my check on my stub for. I don't know what my contribution would be or whatever, but
are you PERS 1 or PERS 2?
PERS 2.
So one thing that's interesting, judges are PERS 2, employees are PERS 3, some are PERS 1, but most are PERS 2. And, I guess I could take judicial notice that I have access to a PERS printout, and I can print out statements, and I can provide that information if somebody were requesting it. So I know that's available. I'd encourage you to find a way to get that to the list.
And also, I haven't received any information. I asked for the same thing, so I haven't received anything from them. I don't get any email responses back. There's been a couple of phone conferences we've had that I've taken time off to receive that I didn't get.
Well, certainly, if you are concerned about not receiving information that you requested via discovery, you're certainly free to file some type of motion or some type of request for relief so that you can have the information that you need that's helpful for your case. Anything else you'd like to share, Mr. McCarthy?
I don't. No, I think that's it.
Okay. All right. Thank you. Ms. Bliss, any response?
Just lastly, Your Honor, I would just ask the court to consider the fact that this is a 20-year marriage. Yes, they have been separated for a substantial period of time, but we still need documentation as of the date of separation as to the accounts, which is what we've requested. I provided Mr. McCarthy substantial leeway. As the court can see, I provided several different discovery dates, several different CR26Is, several emails, just kind of asking for an update. And the last correspondence I sent him indicated if he didn't provide the RFPs that I would be filing a motion to compel. Unfortunately, we're before the court today. I do acknowledge, like I said, that Mr. McCarthy provided stuff last week, but I would also note for the record, this motion was filed on March 8th. So he had 3 weeks after this motion was filed, several months prior to this motion being filed to provide that documentation, and he simply failed to do so. My client did incur substantial attorney's fees in an attempt to gather this documentation, preparing of the motion, being in court today. So we are asking for attorney's fees.
Okay, thank you. All right, so the basic premise with discovery is that there's, while all the information that's turned over may not be absolutely relevant, it provides a very broad scope, allows parties to kind of sift through the information and pick out the information that they deem as most relevant. And a lot of the information that exchanged really is probably not going to ever come before a judge or a court. So there's this idea that discovery is to be broad, and anything that's potentially relevant is probably going to need to be turned over. So it's erring on the side of sharing, if you will. So here it looks like there's the CR Civil Rule 26I conference that's been complied with on at least a couple of different occasions where the parties have conferred in an effort to avoid coming to court. And it looks like the request for production, there's still several items that are outstanding. This has been, looks like the first efforts to obtain discovery for the request for production started back in August, and there's been several follow-up letters at the end of the year and also at the beginning of this year, in addition to those telephone conferences and the like. So I'm going to grant the motion to compel. There's several items that are still outstanding. And so I'll award $750 of attorney fees. The deadline for those requests for productions that have been served on Mr. McCarthy will be on May 9th. And if it's not provided on that date, I'm sure Ms. Bliss will let the court know. So May 9th will be the discovery deadline. Any questions from any of the parties?
Did Your Honor just want to interlineate those changes in my proposed order, or did you want me to provide a clean order?
Let me take a look at your proposed here. I have made those interlineations and I've signed off on that order.
Very good. Thank you, Judge.
Okay, that'll conclude that matter for today.
Your Honor.
Yes, sir.
As the document she has, she fully has everything that she has asked for. We have spoke several times over that deal. And as of now, she wanted a W-2 and my pay stub was all she was needing. So all the other 6 items that she's asked for, we've already discussed. And she has everything that she's wanted.
Well, I would encourage you to revisit the document.
That was 3 weeks ago.
Request for production. So if you look at the request for productions, those official documents that she served upon you, those are the items that the court is concerned are still outstanding. So there may have been discussion between the parties about some stopgap measures about receiving particular bits of information. That's great. I appreciate the fact that you supplied the pay stub, the W-2 and the budget. There's still additional informations that are outstanding in the official request for discovery and the request for production. Yeah, it looks like Ms. All right, that'll conclude today's case. Thank you. Ms. Corey is here with us also, and Ms. Looney is here representing the state.
Good morning, Your Honor.
Good morning. So we're here for a couple of different items. One is presentation. So let's take a look at the presentation related to prior court rulings. There's an order appointing guardian ad litem, and a proposed order that was prepared by Mr. Mir. Did all the parties receive a copy of that? Ms. Corey, did you receive a copy of that? Okay, it looks like your mute was on there, Ms. Corey.
Sorry about that. No, I did not receive that yet.
Okay. All right, and Mr. Reed, did you receive a copy?
Mr. Amir and I have been exchanging drafts. I'm assuming the version that you have right now is the one Mr. Amir is nodding. So I'm fine with that. I understand Ms. Corey hasn't seen it, so she'll probably want to.
Mr. Reed, if I may, Your Honor, if I may.
Go ahead, Mr. Amir.
Yeah, we provided orders last week in order before the court to make sure that we met our deadlines. And we've been, and Mr. Reed is correct, we've been going back and forth with a few things, and we finalized a lot of the matters. It is, I'm in belief that we have now come to an agreement between myself and Mr. Reed. However, the changes that we have made were done late last night, and they have been provided to Mr. Reed, and they are agreed upon. However, they are not before the court because we could not get it in on time due to the fact that me and Mr. Reed were trying to hash things out with our respective clients.
Okay.
With that said, we are now before the court with an agreed upon order, and but it's not before the finalized version is not before the court, and that's my concern. Thank you.
I would also know Ms. Looney hasn't seen the most recent drafts as well.
I did receive some yesterday afternoon, but I don't know if things have changed since then regarding child support. But the state would have requested that Section 20 include that the child is on state medical through the mother, and that Section 22 include proportional shares of daycare expenses.
The child is covered by the father's insurance.
That is correct.
The state is involved because the child is receiving state medical, so we would just ask that also be included as well.
Okay.
And there's no objection on our side on that.
Okay, so it sounds like there's some last minute resolution and coming together. So I have two proposed orders here. One's an order appointing guardian ad litem, and then the other is a parenting plan. Those are the only two proposed orders that I have here today. So let me just ask the parties what your preference is. Since I don't have the most recent iteration of the agreement, would it be wise to circulate the proposed orders to Ms. Looney, Ms. Corey, everybody get their eyes on it, and then come back at a later date, or just have everybody, if they're in agreement, sign off on it, submit it ex parte? Otherwise, we could put a backstop and set a date for review. So,
yeah, I think that'll work, Your Honor. We just set a date, and I suspect we'll be able to get this agreed and signed by everybody.
Mr. Hamir?
That is correct, Your Honor. I believe that I'm on the same page with Mr. Reed. Thank you.
Okay, Ms. Looney?
I would assume that we could go ahead and sign without needing presentation date, but we might as well set one just in case.
Sure. And then Ms. Corey, your input.
That's fine.
Okay. It sounds like if we were to set it over 1 week, I think that should be sufficient. I know this has been dragging on for a bit, and it'd probably be nice to get it finalized. But so let's do that. A week from today is the 11th of April, so we'll set it over to that date for presentation. If the parties have signed off on it and submitted it, then we can strike the matter. Otherwise, we'll have it noted on to resolve any discrepancies.
Your Honor, it might be more efficient if we set it for 2 weeks instead of 1 week, because we still have the other matter that we need to discuss, and that might give us some additional time to present.
Any objection to setting it to the 18th?
No objection, Your Honor.
No, Your Honor.
Okay. All right, let's do that. So presentation on the parenting plan and order appointing guardian ad litem and child support over to the 18th. And then that leads us to today's focus of the motion for spousal maintenance. So I believe this is Ms. Turner's motion. So I'll hear from counsel, please.
Thank you, Your Honor. And we've addressed this on multiple times. I know that the court is familiar with the issues in this case. We're only talking right now about spousal maintenance. We've clearly expressed that there is a need Ms. Turner has been supported throughout the marriage by Mr. Day, and there is clearly an ability to pay. In fact, what we've discovered, the court sets the value, the gross income for Mr. Day at, I think it was $86.35 for child support. Since then, we had additional materials that show his income is even higher than that. Again, clearly there's a need, there's an ability to pay. The couple was married for 6 years. Ms. Turner has a need to get more education. She is suffering from chronic pain due to an accident. All of the factors that show that she should have spousal support are there. The question is how much. Mr. Day is currently paying the mortgage. That's very helpful. And the parties will both benefit from that. However, the house is going to be sold, and once that's sold, she will then have an additional housing need. So as we've expressed in our financial declaration, there's a need of about $3,800 a month. And that includes the housing, which of course, as I said, is currently being paid through the mortgage. That would be our request, is $3,800 a month. However, there is a $1,000 a month that is for child support. So I think there's a helpful offset from that that wasn't included in our financial declaration. So again, there's clearly a need, there's an ability, and we just need to figure out what it is that he needs to do to support her.
Can you remind me, thank you, Mr. Reed, can you remind me of the amount of the mortgage?
$1,400 is the amount that we had included in our declaration.
And that includes taxes, insurance, homeowners, all that?
That's my understanding.
Okay, great. Thank you. All right, Mr.
Mayor. Yeah, my client has no objection paying the mortgage, and I believe he has been paying the mortgage. He's also been paying the utilities, even though that's Erica's responsibility. Mr. Reed's client's responsibility. So it's very important that we if the spousal support is being requested, that it's being requested for the right reasons. In a situation like this, my client is prepared and provided reports in where he's paying the mortgages, he's paying the expenses, he's paying the utilities. In addition, he's also paying the day-to-day activities for the children. My client also does not have any objection to paying the $1,070 since February that was ordered, and in addition to the legal fees that were also presented and ordered by the court. However, the issue with spousal support, it needs to be addressed a little bit further. Mr. Reed also claims that there was a high income that was produced in last year's tax returns, and showing that there's an ability to pay. I do need to remind the court that this was a one-time withdrawal from the 401ks in which he had to declare his income, and the reason why he used that money was to pay for family debt. So his credit does not get compromised, and in addition, that the mortgages and his properties do not go into foreclosure. So there is more to the story than just my client having the ability to pay, and claiming that he's not paying the bills. It's something that needs to be navigated a little bit further in more detail, in my opinion, before a ruling should be made. Because I do believe that my client is being quite prejudiced if he is paying all these bills, and in addition asking to pay another $3,400 in spousal support. So lastly, and most importantly, Mr. Reed's client is collecting an income from the property that is the matrimonial home, which is being rented out, and she's also getting income from the state, which also has to be taken into account for spousal support, and which is not in this analysis. Thank you, Your Honor.
Thank you. Just one point of clarification, Mr. Hamir. You mentioned that the W-2 from 2022 included distribution from a 401k. I showed the W-2 as at 108,146. Is that the amount that you're saying include?
I'll have to double check it, but when I didn't know that we were going to impress upon that. But one of the issues was that there was a one-time income, or there was a one-time draw that was taken out of a 401k and was labeled as income, or was identified as income in the W. I'm not sure if it was part of the W-2 or part of the financial statement, but I think that that's what's being referred to with respect to an income of $200,000 that's been claimed by Mr. Reed since the last hearing.
Yeah, Your Honor, I think I can clarify that. That was their 2021 taxes is where that appeared. We recognize that was a one-time thing. The income from the 2022 taxes would indicate a monthly income closer to $9,200 a month.
Okay. All right. So yeah, I did know the 2021 taxes had an adjusted gross income of 205. 2022 W-2s at 108. So I think that clarifies my question. I appreciate the input from both. Mr. Hamir, did you have any additional comments?
I do not, Your Honor. Thank you.
Thanks. Mr. Reed, any additional on your end?
No, Your Honor. I think we've addressed some of those things already.
Okay. Thank you. All right, so this is it's a shorter term marriage, about 5-6 years in length. The representation is that the mother did not work outside of the home during that time for any length of period of time, and that she's currently working as an Uber driver and renting out a room and creating some income there, and also living off some proceeds from a motor vehicle settlement. So we know that the father's income is in excess of that, about 108,000, at least the W-2. That was the gross from last year. There's also, he's paying the mortgage, which is roughly $1,400. There's also, he's making a child support payment of about $1,071. So I think, that paints a picture where it shows Ms. Turner has a need for some a limited in time spousal maintenance, get back on her feet, whether that's going back to school or what have you, I'm not sure. I haven't been made aware of any specific plans other than that stated desire, and that there appears to be an ability to pay on behalf of Mr. Turner, or Mr. Day, pardon me. So I'm going to set spousal maintenance at $750 per month, and that's kind of taking into account the full picture that there's the mortgage payment, there's also the child support, and it also takes into account the shorter term of the marriage itself. So we'll set that to begin on April 1.
Your Honor, in a previous order, the court ordered that they would be selling the house. I understand the parties are moving to that end. As noted, part of your decision is based on the fact that Mr. Day is continuing to pay the mortgage, but once the house sells, he will no longer be paying the mortgage. Our concern is that will create a hardship for Ms. Turner.
Mm-hmm. Yeah, so I think that for child support purposes, we imputed Ms. Turner at a full-time minimum wage, which puts her about what, $2,100 per month, with the $750. I know rent is not cheap. Rent is, the new apartments, like, 2 bedrooms, like $1,600 a month, depending on what type of apartment you get in location. So I'm sensitive to that, and I don't know. I was aware that the parties were thinking about putting the house on the market, but it sounds like it's not on the market. So I guess there's two approaches to the issue that Mr. Reed raises. One is to address it now and provide some type of conditional or provisional language and a potential adjustment upon sale of the home, or wait until the house is sold. We could take a look at the proceeds, see what the equity is and the division of that equity, and kind of address things at that point. I think I'm leaning more towards the latter suggestion, simply because we'll have more information. The markets, who knows what's going to happen with the housing market with the way things are. Could be super awesome proceeds, or it could be less than desired. Sure. So I think I'll hold off on that, and the parties could readdress maintenance after the sell and division of cost proceeds. Joshua Johnston and Jennifer Johnston, 223-55608. There we have Mr. Lawrence has joined us. Thank you, Mr. Lawrence. He was in a different court earlier today. And then we have Mr. Fuel representing Joshua Johnston. And then it looks like we have Benjamin Brown. Mr. Brown, are you representing Ms. Johnston?
Yes, I am.
Okay. Have you filed a notice of appearance?
I believe so.
Okay, let me just.
I've seen one.
You've seen one? Okay, great. Was it recent, Mr. Brown, that you filed it?
Late last week, I think.
Okay. It's probably in process. So thanks for letting me know that has been filed. So I appreciate that. All right. So on the Johnston matter, we're on today for an interim guardian ad litem report. So Mr. Lawrence is here. It looks like the appointment occurred, I think, on February 28th, if I'm not mistaken. And the order itself wasn't ordered until March 6th. And there were some concerns related to mental health and other things. So I didn't see any update from Mr. Lawrence, and I'm not completely surprised by that because of kind of the short turnaround time. So, Mr. Lawrence.
Yes, Your Honor. I got the notice that I was appointed. I don't remember the exact date, but it was in March. I did get a chance to meet with Mr. Johnston, and I had tried a couple of times to reach Mrs. Johnston, and she did not return my calls. After Mr. Brown was retained, she did email me, and I have an appointment scheduled to visit with her and the children on Thursday. And so I'm just getting started at this point. And I'm not exactly sure what the court really wants me to investigate. I see that I'm to address mental health issues and potential of domestic violence and that kind of thing. But is there anything in particular the court needs guidance on immediately?
Well, taking a look at the guardian ad litem appointment order, I think that was I don't know. Maybe I could turn to the attorneys and you could kind of highlight particular areas that you feel is of particular importance, because the order is pretty broad in that it says, anything that relates to finding a parenting plan, and also talks about mental health issues.
Yeah, if I may, Your Honor, I'll jump in. As the court may, you and I were the only ones of the four of us here for the last hearing, and so I'll just refresh for the record.
Thanks.
Yeah, my client, we filed after a significant amount of no contact between my client and the children. There are other orders in effect that prevent the contact, I believe just a DVPO. And mom at our temporary orders hearing had not appeared, no response had been filed. So we just sort of had a vacuum of information. The court relying on our motion and my client's declaration, where my client was pretty forthright that he's had issues, mom's had issues, VA interaction, both of them with mental health issues. There are the allegations in the DVPO. So there are a lot of things happening. We hadn't had any information or response from mom. So we had a lot of issues raised without any kind of counter position. And so I think from the court's perspective, Your Honor, you were mostly interested in unfortunately, Mr. Lawrence, a little bit of fact finding, generally speaking, to find out exactly kind of what's happening with these kids, both parties, and just to sort of vet mom a little bit, because I certainly didn't have any information. The only information the court had was what my client was able to allege in his documents. So I think at this point, it's almost a bit of a reset to maybe where we hopefully would have liked to have been when we first came to court, since now we've got mom on board, mom's got counsel, Mr. Lawrence, you've been appointed, and I think we just sort of need to get information, generally speaking, to the court to figure out how we can go from my client having zero contact to some sort of we'd ask for some sort of standard sort of parenting plan, and again, from zero to whatever that would be, and whatever kind of timeline would be most appropriate.
Thanks. And then Mr. Brown, do you have any input that might be helpful to Mr. Lawrence?
Yes, I would think an investigation related to anything my client put in the protection order would be appropriate. Any domestic violence or anything about the children being afraid, or just generally that history between the parties and the children. I think that would be a good jumping off point.
Mr. Lawrence, does that give you a little bit of traction and assistance and direction?
Yeah, yes, it does, Your Honor. Like I said, I'm going to be meeting with Ms. Johnston and the children on Thursday, and I've already met with Joshua, so I'll get this thing rolling.
That's great. Thank you. I appreciate that. And we had set kind of this interim date, and I think Mr. Fuel, at that original date that when we set this was kind of just to get a general idea where we're at, and because we weren't flying with both wings, if you will. So are the parties requesting a general time frame in which you'd like to see that interim report?
We've had a little bit of email exchange between the three of us. I mean, obviously we'd like it to go as quickly as possible, but I also understand that this is they're at this point, again, we're really operating out of a vacuum, at least on one side of this thing. So we anticipate that it would, I'm sure, be several months before we'd be able to probably get something thorough. 60 days would be great, but I don't know what the normal kind of rotation on this in Cowles County is for these types of things.
Thanks.
And we're talking about the interim report, right?
Well, yeah, I mean, that's in theory, we're talking about the interim report, or we're talking about the final report. Kind of depends. If Mr. Lawrence goes about his investigation and finds something that is of greater concern, he feels he needs to bring that to the court, he would likely submit an interim report. If he's does his investigation, doesn't find anything that's particularly of significant concern, likely he would just do his regular report and kind of due course. So the guidance would be that this would kind of be a regular speed investigation. If Mr. Lawrence finds items that he feels would require an expedited report or notice to the court, he would certainly bring that before the court, and we could certainly discuss it. So at this point, I guess, the regular kind of report cycle. Mr. Lawrence, can you give a general estimate of what you think that is?
Well, I was appointed in February. I'll make every effort to have it ready in June.
Okay. So we're now at April, so April, May, June. All right.
That sounds reasonable.
Okay. And then generally what I've seen is that Mr. Lawrence will submit that report, the parties will get it, and then one party or both will note it up and say, hey, let's talk about this and review it and see if we can come to some conclusions.
Great.
All right. Yeah. Mr. Brown, just since you're new to the case, do you have any questions or any other concerns you want to address?
I don't believe so. Not this time.
Your Honor, just since we're on the docket and I'm here, I would ask, and obviously, Mr. Brown, you've got your schedule of things, but I believe that we don't have a response from Mom yet. So if we can, if you guys are planning on doing that, that'd be great.
Yeah, this week.
Okay.
There we have Ms. Gilmore. She's present on the
Perfect.
line.
Thank you.
She's representing J.C. Saltzman, and I believe Ms. Saltzman, are you on the line today? Okay.
Yes, Your Honor.
Okay, there you are. All right, welcome. And then Mr. Jones is here representing J. Saltzman. I see Mr. Jones, and I also see Mr. Saltzman, both are present. So welcome to all.
Thank you.
Thank you.
All right, so I understand we're here on Ms. Saltzman's motion for temporary orders. I've read the briefing provided by the parties, and so I'm ready to hear from Ms. Gilmore, please.
Yes, Your Honor, and I can be relatively brief. It is a pretty straightforward motion in this case. As indicated within my client's declaration, the parties were in a committed intimate relationship commencing in February of 2019. The parties subsequently married in June of 2021 and separated for a final time in January of 2023. Prior to the marriage, the parties purchased the real property at one. The respondent husband continues to reside at this residence. After a domestic violence incident that my client again details in her declaration, my client fled from the home and has been renting and living alone ever since. My client stayed at home or worked minimal part-time minimum wage jobs during the marriage. She's been forced to rely on credit cards and loans from family to survive and to reestablish herself. Respondent presents a pay stub from November of 2022 that shows a gross annual income of $221,737. I divided that by 11 months. That gives him a gross monthly income of $20,157, or a net monthly income of $12,945. Even with an inflated budget presented by respondent, we believe that he has an ability to pay of over $5,000. My client needs support to help her transition, reestablish herself, especially since the situation is that respondent continues to reside in their household. We believe the house does have substantial equity, so we do need to deal with that through the process of the case. However, again, my client wasn't working at the time of the parties separated. She is trying to reestablish herself, but she does need transitory support in this case. So we are asking the court to award spousal support in the amount of $5,000 and award attorney's fees in the amount of $10,000, given the great disparities of income. Thank you.
Thank you. Ms. Gilmore, one quick question. Is your client, is she currently working?
It's my understanding she was applying for employment, but she wasn't currently working. JC, can you give us an update on that?
Yes. So I do DoorDash, which supplements about how much I was making at my last job. So that's what I do currently.
Okay. Thank you. Thank you, Ms. Gilmore. Mr. Jones?
Yeah, Your Honor, this is an 18-month marriage. Both parties are in their mid-20s. Wife worked the entire marriage off and on at restaurants, wherever she could. There's no children. This is not a spousal support case. The presumption in a short-term marriage is to put parties back in the position they were in prior to the marriage. If wife's awarded temporary support, that's going to put her in a better position than my client. We can look at wife's needs. She's got a total monthly expenses of about $5,500. If the court's going to give her any support, that should be reduced by minimum wage to bring it down to around $3,000. And that's even accounting for her inflated financial declaration. She's got things in there. For example, she's got $873 worth of credit card debt that we haven't been provided any information about. She's asking for my client to pay her car loan, and all other insurance is another $500 or $600 per month. So that $5,500 needs to be reduced by about $1,000, and then take away another $2,500 for minimum wage, and then you're left with what support may be reasonable for a very short period of time. Again, this is an 18-month marriage, so if the court's going to award any support, it needs to be for a 3-month period to allow that transition. There's no need for attorney fees, $10,000. This is not a 20-year marriage. We have complicated assets. If this court awards any attorney fees, you're putting fuel to the fire, and this divorce is never going to end, and we're going to litigate until the cows go home. This is an 18-month marriage that needs to be resolved quickly and efficiently. It's not a spousal support case. There's one house we're trying to divide up. These folks are 25, 26 years old. Let's get this case resolved. Let's get wife on to her next job. Let's get husband off. And let's get this case resolved. So no spousal support, no attorney fees. That's my argument. Thank you.
Thank you. Ms. Gilmore?
And very briefly, Your Honor, I think the situation would be completely different if my client was continuing to reside in the household. But again, husband attempts to allege isn't community property. We submit materials that my client was on the deed. She submits under penalty of perjury that she contributed to the down payment. So my client is again having to completely reestablish herself. We can go tit for tat on the financial declaration. I submitted within our reply declaration that he's spending allegedly $1,000 on food, over $1,000 on transportation, $1,500 on credit cards that we don't have information for. So I can walk down his budget as well. The facts of this case is that he has a $20,000 gross income, and even during the marriage, my client had an annual income of $15,000 a year. I do agree that support shouldn't be long-term, but a transitory support is supported by case law. I don't think there's any sort of case law demanding the court to award only 3 months of support. So we do ask the court grant temporary relief, grant temporary transitional support, and award of fees in this case. Again, my client there's a huge disparity of income. My client has received no support from husband, and frankly has been having to get loans from family to survive.
Thanks. Okay, so what I understand from the parties' relationship, they purchased the home sometime in June of 2019, and there was likely they moved in thereafter, and then they were married in 2021 and separated just shortly thereafter in 2023, 2022, about 18 months as far as marriage goes. It sounds like Mr. Saltzman makes a good living doing what he does. And prior to the marriage or during the marriage, it sounded like Ms. Saltzman didn't have to worry too much about income because Mr. Saltzman was making a good income. And so that allowed her some freedom to work on one particular job and then maybe move to a different job based on whatever her desires were at that time. So generally, I take into account that it is a short-term marriage, and I also take into account that there was cohabitation prior to the marriage. So I think it's appropriate to kind of take a look, and the goal is to put the parties back in a position, an economic position of where they were prior to the marriage, since it is a short-term marriage, and the case law talks about allowing for inflation and the like, and we know that inflation has been a thing in the past a little bit. So there's a presumption that there's in a short-term marriage that there is no maintenance, and then except in extraordinary circumstances or for allowing for a brief adjustment period, that there may be some type of spousal maintenance would be appropriate. So it sounds like the one thing that was interesting to me that at this point, Ms. Saltzman is not working. I don't know if there's a great urgency for her to work or not. It sounds like she's able to meet her needs, maybe not at the level that she would desire or would like, but is able to meet her needs. The sense is that if there was a separation back in, when was the alleged separation date? January 2023. There it is. That if there was a really pressing need, that there would be kind of a scramble to get a job, and I'm not seeing that. So that tells me maybe the need is not as great as it was pled to be. So therefore, I'm going to limit the amount of spousal maintenance for an adjustment period of 4 months, and it'll be $1,500 per month. I'll award attorney fees of $2,000. There's a degree of inequality in the incomes that will help offset that. There's hopefully the parties can come to some type of agreement here with there's pretty limited issues, and hopefully those attorney fees will not be consumed. So that's the court's ruling. Any questions or clarifications needed?
No, that was perfect. Thank you, Your Honor.
All right.
Does the court want to address the additional expenses? Is the court just ruling the keeper continues to pay the household expenses?
So when you say household expenses, what do you mean?
Mr. Saltzman will maintain the marital, the community, or the house and all those bills, yes.
Right. I think that's probably in everybody's best interest that he continues to make the mortgage payments and provide for its upkeep and the like. Ms. Gilmore, were you suggesting a ruling on vehicle possession and who pays for it and credit cards and the like?
Yeah, some of that, just briefly, let me bring up the motion.
And my position would be each pay for your own.
Right. I think, you know, the vehicles that's a pretty straight call, at least in my mind, is that if one party has a vehicle, they're in the best position to care for it and provide for it. So that would, I'm fine with that. So whichever vehicle they have, I think mom has the Honda or the wife has the Honda and the dad has the Mercedes. So they'd each keep those respective vehicles and be responsible for the payment thereof.
And then I just have a Bank of America credit card, a Fiber credit card, and American Express. I would ask that he maintain health insurance if my client's on the policy pending the dissolution.
Did I see in the pleadings there, Ms. Gilmore, that I may have misread this, but I thought I had read that it was proposed that Ms. Saltzman would be paying for the Bank of America, the Fiber, and the American Express. Did I read that incorrectly?
Those were included in our financial declaration because that's the current situation, but we did not meet that request in our motion.
And I believe, Mr. Jones, in your pleadings, there's 2 cards from JP Morgan that had a balance also.
Yeah, well, right now the situation is we're both dealing with the other side's credit cards we don't know anything about. So my suggestion would be you pay for the credit cards you have in your possession until we can figure out, these are all going to need to be divided in this divorce. We need to do discovery on what these are being used for. At this current time, each party should be responsible for the expenses on their financial declaration.
Okay. Yeah, as far as the credit cards, it's not crystal clear to me the origin of those and how they were utilized during the marriage. So I'm not clear on that. So I'm not going to make a ruling on who pays for that, other than if a party still has. Are the parties, like, for example, Ms. Gilmore, the Bank of America, the Fiber, the American Express, are those issued in the wife's name only, or is it a joint account? That's Mr. Jones, that's your understanding?
I frankly am not sure.
Okay. And then Mr. Jones, is the JP Morgan cards, are those expressly in Mr. Saltzman's name?
I believe so. He can nod. Yes, they are.
Yes. Every credit card that both of us have, we are the sole users of the credit card. We are not joint on any accounts, including the auto.
Okay.
Thank you.
So I think at this early juncture of the case, the parties who have, each party who has a credit card in their possession and it's listed in their name, they will be responsible for making minimum payments or whatever payments they deem appropriate.
Great. Thank you, Ron.
Thank you.
All right. I think that addressed the issues that were brought before the court today. Any additional items or clarification?
I think it's pretty straightforward. We can set it on for presentation, but I think that honestly, we'll probably be able to circulate for signature.
I don't think it'll be a problem.
Okay, let's just set up for presentation on the 18th of April at 9 a.m. And if the parties sign off on that, they can be submitted ex parte and they'll sign off on it and we can strike the 18th, but otherwise that'll be our backstop.
Great. Thank you, Ron.
Thank you.
Okay. All right. Thank you.